Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to talk to you about a very important Board of Immigration Appeals decision that was issued just recently. And that decision affects or may affect many applicants for cancellation of removal. As you may aware, if you have a pending case or if you're following any immigration news, in the past 5 or so years, many lawyers were advising clients, those who have lived in the United States, resided in the United States for a long time, and did not have any papers, that if they file for asylum and later referred to court, those people will be able to file for cancellation of removal or green card with the judge. And many people were confused about this relief. Many did not really understand what they were doing. They received employment authorization for 2, 3, 4 years and now ended up in removal proceedings facing deportation. And as the immigration laws are changing, I would say practice of immigration laws, and the standards becoming more and more disfavoring immigrants, we can see that there is the same trend in removal proceedings, in proceedings that right now I believe cancellation of removal is one of the most popular reliefs that the person would ask if he or she is facing deportation. So just today I received a notice about a new decision from the Board of Immigration Appeals addressing specifically cancellation of removal. And what this decision is saying is that basically it will be very hard to receive cancellation of removal, and this is why. Well, first of all, the decision starts stating that an applicant for cancellation of removal has to meet exceptional and unusual hardship standard in order to qualify for cancellation of removal. Despite that there were cases in the past saying that it's the standard that is called exceptional and unusual hardship equals to extreme hardship, but let's leave that point alone. That's not what the decision is mostly about. The decision is about medical hardship in particular. The decision states that if an applicant for cancellation of removal is using medical condition of his or her qualifying relative as the reason for to meet the standard of hardship, the applicant has to show that the person suffers from serious medical condition, that the person, if he or she is going to accompany the applicant to the country of removal, is not going to have access to reasonable medical help. That adequate medical help is not reasonably available. Okay? So let's talk a little bit about facts of this particular case. The case is called Matter of JJG 27 I&N Decision 808 2020. In that case, what happened is this. The person, the father of the family, is being deported to Guatemala. He has children. He has a wife who is a lawful permanent resident. And now, some of his children suffered from anxiety disorders, and we're talking about one of his qualifying relatives. Right now, that relative is suffering from what court stated can be a serious medical condition, especially if it's not treated. But right now, the person receives treatment in the United States funded by the government. Okay? So the family is using state benefits to fund the treatment and address their other medical needs. Then the decision states that the person, the qualifying relative, stated that they will be accompanying, in case of removal, the applicant to Guatemala. Then there is also evidence in terms of person's testimony stating that she did internet research and found out that the treatment for the same condition in Guatemala is going to cost $1,100. We also have testimony that previously the wife of the applicant in Guatemala was receiving treatment in Guatemala for free, meaning that Guatemala has free medical care. And we have evidence that Guatemala in general has lower standards for medical care than in the United States. I would say that 99% of applicants for cancellation of removal will have similar evidence, okay? So what went wrong? Why the judge decided and Board of Immigration Appeals decided that that's not enough? Basically, what went wrong in this situation are two things. Number one, state benefits. Even though the decision does not specifically points out that that was a problem, for cancellation of removal, when applicant is filing for cancellation of removal, he or she has to disclose if any of the members of his or her family are using state benefits. So judges generally do not like if people use state benefits, or if applicant cannot support his or her family to the level where the state benefits are not being used. But then they talk about the evidence of availability or unavailability of the treatment for this medical condition in Guatemala. And even though applicant did produce reports that, generally speaking, in Guatemala, the conditions of healthcare system are much worse than in the United States, they didn't go into depth and didn't produce, let's say, a statement from a medical professional stating that, for example, this particular drug that is needed to control the condition is unavailable or is available only at high cost if an individual will have to purchase it, let's say, that the government is not going to cover by general medical insurance or whatever the system there is, this treatment. They didn't produce evidence that they will not be able to make adequate money to obtain this drug. So they didn't really bother with the details, okay? And now we have this bad decision that's bad for all of us, those who are representing people in cancellation of removal and the applicants in cancellation of removal. This seems to really focusing on this one particular prong and makes it very difficult to meet it, okay? This is something that you need to know about if you are going to file or you are in the process of filing for cancellation of removal. Your attorney or you really have to read the decision and focus your attention on how is that you will be able to withstand the challenge to the fact that the medical care is not, how they phrased it, adequate medical help is not reasonably available in the country of removal. And of course it's relevant only in the case if the qualifying relative is going to travel with the person who is being removed to that country, okay? I suggest that you do read the decision. I will try to post it so it will be available in the description of the video. I think it's a very important decision currently because it also states that general conditions that are less or they have less equality than in the United States. That's just the regular consequences of removal, the decision states. as well as if children will have lesser opportunity for education. It's also, by the way, this point is also very often used in cancellation of removal cases when we're trying to establish hardships. They also are not going to be afforded a big effect for the cancellation of removal cases. So this is a really tough decision. I'm not sure if it will be appealed to the federal court. We're going to see what's going to happen with that. But right now, this is the decision that will be used by immigration judges. Don't make mistake about it. And you have to adequately prepare to address the points in that decision. Point about medical hardship, about less favorable conditions in the country of removal. Do not be confused about whether or not the person who is a qualifying relative will or will not be traveling with the person who is being removed together to the country of removal, because it seems to also, there was a problem in the decision about that. The testimony of the witnesses varied. The husband stated that the children are going to stay in the United States if he's removed, and the wife stated that they will be going with the husband altogether to the country of removal. So all these points need to be reviewed. And I hope this video was helpful. Now you know what you need to prepare for, and stay tuned for more tips on immigration. Thank you.